Hi, my name is Roger Bora, creator and founder of the Trademark Titan blog, and today I'm going to talk about intellectual property, some overview of trademarks, copyrights, patents, and trade secrets. I also talk a little bit about M&A transactions and due diligence considerations for brand owners as well as acquiring parties and venture capitalists. The topics I'll cover are listed right here. IP basics. So what are trademarks? Well, as a starting point, trademarks are anything that identify the source of a product or service. Think of the Nike swoosh, think of the NBC chimes. So anything that brings to mind and identifies the source of where a product or service is originating from. What's a copyright? What's the difference with a copyright? Well, trademarks and copyrights do have some overlap. If you think about trademark logos, artwork, not only can a logo design identify the source of a product or service, but you can also have some creativity in the artwork itself and be subject to copyright protection. But typically, copyrights protect the expression of original works, and that can include music, paintings, artwork, photographs, software. And then we have utility patents. There are also design patents, but for this presentation, we'll focus on utility patents. And utility patents protect new and useful, non-obvious ideas, inventions. And then trade secrets. Trade secrets protect the valuable information that provides a company with a certain economic advantage. Trademarks. There's something known as the spectrum of trademarks. Won't get into this too deep today, but just understand that as you're thinking about a new product name, a new company name, or perhaps a new service mark, that there's something called the spectrum of trademarks, and they range from generic words that are never protectable as a trademark up through descriptive terms, suggestive, arbitrary, and coined marks. So, think of descriptive terms as something that describes the product's, an attribute or a characteristic of a product or service. Think of suggestive marks such as, say, Die Hard for batteries. Arbitrary marks, words that are used in very arbitrary ways. Think of Apple for computers. And then coined marks, terms that are made up, not seen before words. So there's something known as a spectrum of trademarks. So while you're considering your product name selection, be thinking about this and be thinking about the fact that not all words are going to be created equal when it comes to providing you with strength of a trademark. And if you're interested in learning more about this issue, you can go to my blog at trademarktitan.com and listen to podcast 4. You can also check out this book. This is a book that I've been promoting for many years. It's a book that talks about the thinking behind selecting trademarks and how to bring your brand to the top of the mind of customers. It's a very good book. It's very inexpensive. You can read it in a few hours. So how are trademark rights created? Let's talk. There's typically two ways. You have first to file countries. You have countries where if you file your trademark application first and you registered your mark, that party typically wins the race. As it is a first to file, you can be using your trademark there for many years, but country laws will not recognize your trademark rights. So it really can be a race to the trademark office. You don't want to be the party that's been using the mark for a number of years and find out that somebody, after you've been using it for a number of years, registers your mark, and now you have to be concerned about whether or not they're going to enforce their trademark rights and their trademark registration rights. So think about this as the first to file countries is really a race to the trademark office. Now we also have first to use countries, much like the United States, UK, Australia. It's really whoever uses a trademark first creates those trademark rights. As long as you're not infringing somebody else, you've created trademark rights. But the trick here is that you've created them in the geographic region where you've been conducting business, perhaps where you've been selling. And so you still want to be thinking about national trademark rights. So if you're a local company, you're thinking of starting out in a certain area, maybe in the same state, maybe in a few states, you want to definitely think about preserving your rights because trademark registration is still important in those first to use countries. And here are some benefits. You have the presumption of ownership and validity with a trademark registration. And again, the key thing for me is it preserves your right to expand nationally. You want to have that preservation. So in other words, if you were to start using your trademark today and you filed your trademark application, say a month ago, or you filed it, next week, and then you're only using your trademark locally. But then somebody comes along in a month or 3 months or 6 months and starts using the same trademark or similar trademark or confusing with similar trademark in another part of the country, you may now be prevented from moving into that part of the country because they have trademark rights there, you have trademark rights here. And had you filed a trademark application before they began using, that would have preserved your ability to expand at a later time into their market. So you still want to be thinking about registering your trademark even in first to use countries to provide you with that kind of that preservation of expansion rights. The other thing here that I see quite a bit is companies who think that they've been using the mark in the US for a number of years and they can freely expand in other countries. You want to be careful about that because trademark rights are country specific. So the fact that you have a US trademark registration, you've been using it for a number of years, still be thinking about if you're expanding globally, make sure that you're protecting your trademark in these other countries as well. If you're interested in the issues of US trademark registration and international trademark registration, you can listen to my podcast on episodes 6 and 7. So likelihood of confusion. This is an issue that comes up frequently in my practice as companies are looking to add new product names. Maybe they're starting up a new LLC and they're looking around to see if they can use a particular name. Well, this is the test because the test for trademark infringement is not whether or not somebody is using a similar trademark for another type of product, and it's not whether or not people will be confused as to what they're buying. The test is really, are they confused as to the source of where that product is coming from? So the test we want to be thinking about is, would the average consumer believe that the party's respective goods and services are of the type that would originate from the same source? So think of running pants, running shoes. Different products, but if both parties were to use, say, the word Nike on their products, consumers would certainly be confused as to the source of the goods. So we want to be thinking about source confusion, not confusion as to what someone's buying. And here's an example. Oxygrow for chemicals for enhancing plant growth versus Oxygrow for grow lights for enhancing plant growth. Different products, different trademarks, but the fact that these trademarks or these words are pronounced the same, I think you can argue the goods are related because I think the average consumer would reasonably believe that these particular products are of the type that would originate from the same source. So if you have two different products, similar trademarks, the question here is, would these marks be considered confusingly similar? I would say they are. I think this would be considered a high risk. And if you're interested on trademark selection and what constitutes likelihood of confusion during the trademark selection process, you can check out my podcast 5. Let's take a look at some misconceptions of trademarks. These are the things I see quite a bit. A company files for their LLC, they receive their business name registration, maybe they receive a state-issued trademark registration, and they think that gives them the right to use. Well, it doesn't, because if somebody else has prior trademark rights, those prior trademark rights would actually trump a later business name reservation issued by a state. Or if they receive a trademark registration, it gives them the right to use. Well, that's also not accurate, because if somebody was using first just at common law without a trademark registration, that prior use would actually trump any trademark registration that you receive. So again, this is why we want to make sure that we're clearing our trademarks well before we launch our name and before we file for trademark protection. Or you search the trademark office database and you didn't find the trademark. Well, we have to also be thinking about confusingly similar marks. It's not just the exact spelling. We need to be thinking about confusingly similar marks, and not only similar marks, but are there related products being sold in connection with a similar mark? So we need to be thinking a little bit more broadly when we consider. Let's take a look now at international. There's something called the Madrid Protocol. It's a filing mechanism for companies who want to protect their trademarks internationally. And so you can use this as a filing mechanism. It can reduce the costs, but it's not something you would use in every situation. So you want to be careful here not to be attracted by the absolute cost savings. You want to be thinking about the other types of risks that come with the Madrid Protocol. And so you'd want to take a look at that. Also, EU trademark filings, EU trademark registrations can protect 27 countries. So it is an inexpensive way to protect the European Union countries. And just by way of example, here's some kind of the estimated known costs, what we would expect to see in an international trademark filing. I've listed the types of fees we would anticipate. The fees that are not included in my estimates here in a moment are going to be the fees that cover trademark office objections, third-party objections, maybe oppositions, but just straight through filings. If you were to file, say, in 10 countries, I selected 10 countries, we ran some budgets, you could expect to spend about $22,000 from application to registration, assuming we don't run into any hurdles in these countries. Now, if you use the Madrid Protocol for those same countries, it's $11,000. So that's a very significant savings for using the Madrid Protocol process. So again, there are pros, there are cons. You want to make sure you speak with your trademark attorney before you just dive into the Madrid Protocol. What about an EUTM? So we have, let's say you want to file in these countries, France, Germany, Poland, and Spain versus the whole EUTM. So to file these national filings, you could be looking at about $8,000 from the beginning, from application to registration, or you can file in the EU and protect 27 countries at about $3,600, assuming there are no barriers. So again, know these options are available and speak with your trademark attorney about it as you move into the international filing process. So what are some due diligence tips? If I'm an investor and I'm thinking about investing in a company, or if I'm a buyer, I want to know where the trademark's been protected. Have we secured registration in the core countries? Have we protected the core trademarks, the core products? Making sure also there's not non-use vulnerability. What does that mean? Well, that means that if a company has secured registration internationally, after 3 years of registration, those registrations can become vulnerable to non-use. We want to make sure the company has been using the mark, selling products in those countries, and we're not buying registrations that are vulnerable to cancellation. Also, do we have trademark licenses? Should we have trademark licenses? Or should the company we're looking to acquire have had trademark licenses put in place? What about recording those licenses? Some countries require that if you have a trademark licensee, for example, Mexico, that the trademark license be recorded, because if it's not recorded in these recordal countries, the trademark use by your licensees may not be deemed to be use at all, and therefore the registrations could be vulnerable to attack for non-use. We want to make sure there are no liens on the IP. We want to make sure the chain of title is clean. We don't want to buy assets where the chain of title is not a clear chain of title. All right, let's jump over to copyrights. What are some examples of works that are eligible for copyright protection? Well, website content, photographs, product manuals. If you sell products and you have a product manual and this is something that could be eligible for copyright protection. Videos, any marketing materials and software. So, if you have a company, you certainly want to take an audit of the types of works that you use on a day-to-day basis that you think are quite critical to your business. And we'll see why this is important. So what is eligible for copyright protection? Well, it has to be original. So it has to be a work that's original. to the creator. It has to be comprised of what's known as protectable expression. It can't be facts or ideas. It has to be something more than just an idea. And it has to be fixed in a tangible medium. Okay, so it has to be recorded, it has to be written down, it has to be in some way fixed in some tangible medium. And federal copyright protection is not necessary. So you just creating something gives you copyright protection in the work, but you don't receive the registration benefits. And you will certainly want to look into this to know what you are gaining by securing copyright registration. And those benefits can be very, very valuable. And as you'll see in a moment, my podcast 8 talks about those. So what does copyright protection not protect? Well, it doesn't protect facts and ideas. That's for, ideas or for patents, right? Principles, concepts. So if you have an idea of a product or an invention, copyright is not going to get it done. So you want to make sure that if you identify your intellectual property, identify your inventions, and make sure that you're protecting them in the proper way. If it's a trademark, you need to protect it via the trademark registration. If it's a copyrightable work, you want to use copyrights. You want to know what you have, identify how to best protect it. For example, slogans, short phrases and single words are not eligible for copyright protection, but that would be for trademark law, right? So a slogan, something like that, a word or a phrase, that's something we would want to look at for trademark protection. This is critical for an M&A transaction, and that is who owns the copyrights. If you're a company and you commission some projects and a third party were to create, say, a website, maybe make some software, write some software for you, absent an assignment agreement, you're likely not going to have the copyright ownership. So you want to make sure that if you're commissioning works from a third party, that the agreement itself is assigning the copyrights to you. Otherwise, you're essentially receiving a license from these third parties. So you want to make sure that if you have anything that's been created, a website, again, a product manual, software, anything really critical to the company, even your trademark logo, go back, look at your agreements, make sure the copyrights were assigned to you. And if they were not, you will definitely want to reach out to these vendors and have them execute a copyright assignment. So what are some due diligence tips on the copyright side? Well, again, we want to make sure that we own the copyrights. Anything that was created for us outside of, say, an employee's duties have been assigned to us. And be aware of co-authors, right? And in the copyright world, co-authors can be have access to the profits that one of the other co-authors generates just by the fact of being a co-author, unless there's a writing or some form of an agreement otherwise. Making sure that the founders of the company, if I'm going to invest into a company, I want to make sure that anything that's critical, any IP that's critical, it could be patents, it could be trade secret, as we'll see in a minute, making sure that the founders have assigned the intellectual property to the company owns title to the IP. Again, podcast 8 at trademarktitan.com discusses more about copyright issues. Let's take a look at patents. Utility patents protect functional ideas, right? The ideas, they have to be useful, novel, and non-obvious. They can't be obvious to someone skilled in the art. So if you have an invention, you're going to need to meet some of these basic hurdles, clear these hurdles to actually be eligible for patent protection. So what does patent protection actually give you? Well, it gives you in the US, it gives you the right to exclude others from making the invention or selling or using or offering for sale the invention. It does not give you the right to use the invention. This is something that if I'm going to acquire a company or I'm going to invest in a company, I want to know what are the patents, what do they cover, and making sure that I understand that the patents that the company owns does not give them the right to practice the invention. It actually gives them the right to exclude others from practicing the invention. What does that mean? That basically means if there's an invention on this chair, so there's an invention, there's an inventor, there's a company that owns a US patent on this chair, and I invent this product, the rocking chair. Well, in order for me to practice my rocking chair, right, I need to actually practice the other inventions. So in order for me to practice my rocking chair, I will then need to go and receive a license from the party that owns the underlying chair patent. And therefore, for that reason, my patent does not grant me the right to practice my invention, because by me practicing my invention, I am infringing the other party. So I may need to go out and receive a license. On the patent side, patent application timing, we want to make sure that if you're looking to acquire a company, you're looking to sell your company, or you're looking to invest, that if there's any critical inventions, that these inventions, the patent application be filed within 1 year of the disclosure of the invention, or the clock can run out and the invention becomes part of the public domain. And in some foreign countries, they may not have any grace period. So again, you want to be careful about disclosing your invention before you've spoken to a patent lawyer about kind of getting your filings in order based upon where you're filing. So what are some due diligence tips on patents? Well, we want to make sure the inventors have assigned their patentable invention rights to the company. So again, if I'm investing in a company, I don't want to invest in a company unless the founders have assigned the intellectual property that's critical to the company, or I could be investing in a company that doesn't have the critical assets. You also want to look at, do the granted patents actually cover the current commercialized products? There are situations where a product will evolve over time, and that product at some point in time may no longer be protected by and covered by the patents. We want to make sure if we're buying a company, or again, we're investing in a company, what we're investing in, the commercialized products are still actually protected under the patent. And again, joint owners, we want to be, just like copyrights, you want to be thinking about this. Trade secrets. What's a trade secret? Well, a trade secret is essentially information that a company has that's been maintained as a secret, and it provides them with an economic advantage over their competitors. And we want to make sure that we've taken reasonable steps to maintain the trade secret, because companies that do not take reasonable steps to maintain the information as a trade secret can lose that legal trade secret protection. And here are some examples. Are there policies in place? Are there procedures in place? Is the information controlled in a physical location? Is it in a safe? If it's a recipe, is there easy access to this information? So how about employees? Have employees that have access to this information, are they under any form of agreement? So you want to make sure that if you're a company that believes you have a trade secret, or you have a trade secret, that you take the steps necessary to maintain it as a trade secret, because when you go to sell your company, these are the things that are going to be flushed out during the due diligence process. So in a due diligence process, what are some of the typical requests for owned IP assets? Well, they include, do you own patents? Do you have know-how? What about your copyrights, registered and unregistered? What about your trademarks, registered and unregistered? Trade secrets. What about software, domain names, social media names? These are things that are going to come up. And if you're claiming ownership of these types of assets, another question that will come up is, well, please provide us with physical documents supporting your ownership. And again, if you go back and think about the copyrights, if you had third-party vendors creating your copyrights, do you own those copyrights? What about the trademark logo? Do you own the trademark logo if it's protectable by copyright? So what about the patents? Were the patents and the trade secrets, were they assigned by the founders, or from the founders to the LLC? So these are things that are going to come up during the due diligence. And they're going to be IP representations and warranties. You'll have to give reps and warranties if you're selling your company. And you want to make sure that you can do that. So you want to make sure well in advance of a transaction, you are getting these things taken care of. You want to make sure that you can go to the table, negotiate a deal, sign these reps and warranties, not be concerned that the buyer is going to back out or the buyer is going to negotiate down the sale price once some of these things come to light that maybe all the IP is not in order. And some of the reps and warranties will also be the seller's IP. Hey, my IP is not infringing a third party. Can I rep and warrant that? So to the best of my knowledge, that we're not aware of a third party infringing our rights, that we're not under some threat of suit, and that our employment vendor agreements are in order. Okay, so these are things that we're going to need to deal with. How about liens on IP? Have we handled any of the liens that are on the IP? So again, these are some of the things to be thinking about, from basic trademark law, basic copyright law, right through some of the more sophisticated issues that will come up during a transaction. I hope you've enjoyed this presentation, and I look forward to having you back next time.